Welcome to the Neufeld Legal Restaurant Business Law video series. My name is Christopher Neufeld, and I am a business lawyer with nearly 20 years of legal experience, with a strong emphasis on serving the highly challenging hospitality industry, from restaurants to bars to catering operations. In this particular video, we will be looking at one of the first steps in acquiring an existing restaurant or bar, namely the letter of intent. A letter of intent is often entered into between the purchaser and the vendor following the successful completion of the first phase of negotiations to acquire an existing restaurant or bar. The letter of intent generally, but not always, describes the purchase price or a formula for determining the purchase price, and certain other key economic and procedural terms that form the basis for further negotiations. In most cases, the purchaser and the vendor do not yet intend to be legally bound to consummate the transaction, and expect that the letter of intent will be superseded by a definitive written acquisition agreement. Alternatively, purchasers and vendors may prefer a memorandum of understanding or a term sheet to reflect the deal terms of the acquisition. Although the vendor and the purchaser will generally desire the substantial deal terms outlined in a letter of intent to be non-binding expressions of their then current understanding of the shape of the prospective transactions, letters of intent frequently contain some provisions that the parties intend to be binding. Furthermore, the binding provisions of a letter of intent generally relate to the process of conducting negotiations and proceeding towards a definitive agreement. As a prospective restaurateur, you should seek the benefit of experienced legal counsel before entering into a letter of intent. What portions of the letter of intent should be binding or non-binding, and the risks of entering into a letter of intent at all are important issues with a heavy legal overlay. The level of detail in the letter of intent and which issues should be addressed or deferred are key strategic questions that should be discussed between yourself and your lawyer, as well as their likely impact on the negotiations of the restaurant or bar's acquisition should be fully explored. There are several reasons why letters of intent are used. A purchaser and a vendor frequently prefer a letter of intent to test the waters before incurring the costs of negotiating a definitive purchase agreement and performing due diligence. The parties may also feel morally, if not legally, obligated to key terms once they are set down in writing. Sometimes the deal terms are sufficiently complicated that it is helpful to put them down in writing to ensure that the purchaser and the vendor have consistent expectations with respect to the proposed acquisition. Signing a letter of intent at an earlier stage of the acquisition process, rather than waiting for the definitive purchase agreement, can facilitate compliance with regulatory requirements. Also, a signed letter of intent may assist the purchaser in convincing prospective lenders or investors to evaluate the transaction for purposes of providing the necessary financing. Letters of intent are also used to define the rights and obligations of the parties with a definitive purchase agreement is being negotiated. For example, an exclusivity provision is often included, which prohibits the vendor from negotiating with another party while negotiations with the prospective purchaser are ongoing. A letter of intent, either alone or in conjunction with a separate confidentiality agreement, will usually permit the purchaser to inspect the target's properties and to review its operations and books and records while simultaneously restricting the purchaser's ability to disclose and use the target's trade secrets and other proprietary information received during negotiations. A letter of intent often covers how expenses of the acquisition and negotiations, such as fees and expenses of brokers, lawyers, and other advisors, will be paid and limits the rights of each party to publicize the acquisition or negotiations without the consent of the other party. A letter of intent may establish a time frame for conducting due diligence and closing the acquisition, and certain other milestones and preconditions prior to the execution of a definitive agreement or the closing of the transaction. An exclusivity provision in the letter of intent may prevent the vendor from introducing other interested parties to the acquisition to enhance his negotiating position with the purchaser. If actual or suspected problems are uncovered during due diligence, the purchaser may try to use that information to negotiate a lower purchase price or more favorable terms. A signed letter of intent, even if not binding, together with the purchaser's inspection of the target's properties and review of its operation and books and records, often will create an expectation on the part of the target's employees, vendors, customers, lenders, and/or investors that a sale of the purchaser's restaurant will occur. The purchaser's investigation of the target may also uncover information that can be used by the purchaser to compete with the target if the sale is not consummated, even if the target receives protection against the disclosure or use by the purchaser of the target's trade secrets and other proprietary information. Notwithstanding these considerations, a vendor is often as insistent as a purchaser that a letter of intent be executed before work of a definitive purchase agreement is commenced. One reason may be that negotiations of a letter of intent provide the vendor with an excellent opportunity to negotiate certain key acquisition issues at a time when the vendor possesses maximum leverage. The vendor may also feel pressure to show some evidence of a prospective transaction to lenders or other interested parties. If the vendor is not bound by an exclusivity provision, it may want to use a letter of intent to prompt other potential purchasers to compete for the business transaction opportunity. At the stage in the transaction when the letter of intent is signed, the transaction itself usually is still more conditional in nature. Most often, many terms have not even been considered, much less discussed or settled. Moreover, due diligence is rarely completed at this stage, and quite often not even commenced, and both parties may be oblivious to many potential pitfalls. Accordingly, the purchaser may want to avoid specifics on many business deal points. This strategy may enhance the purchaser's negotiating position by deferring discussions on these key issues until after the purchaser has completed its due diligence and the vendor's negotiating position has been compromised by executing a letter of intent. The vendor, on the other hand, will want in most cases to resolve all important issues at the letter of intent stage when the vendor may have its greatest negotiating leverage. For legal representation and effective legal counsel from restaurants, bars, and catering businesses, from acquiring an existing restaurant or bar, taking on restaurant partners or financial investors, to franchising your successful restaurant, to take your business model national and beyond, feel free to contact myself by telephone or email as set forth in this video or through our website www.restaurantlawyer.ca. Thank you.